Increasingly, there is a view that traditional or not so traditional competition law enforcement should be supplemented by pro-competition regulation, and not just in key digital markets, but across the economy, so as to harness the power of data both to strengthen competition, but also to spur innovation. Australia's consumer data right, conferring on consumers the ability to access and transfer their data between providers, is at the very forefront of these developments. And the banking sector is the first in which this pioneering and experimental reform will take effect. Of course, open banking itself is not new, but there are features of the consumer data right regime that are novel, and some of them even controversial. And its rollout in one of the most important and certainly one of the most talked about sectors of our economy gives us the opportunity to observe firsthand its potential impact. Tonight we have a fantastic panel who are going to help us reflect on the rationale for this reform, in relation to which I would be remiss not to mention that we in fact probably have the architect of the reform in the room, Peter Harris, former chairman of the Productivity Commission, given that it was the Commission's data report that is the genesis of this idea. They're also going to help us reflect on the implications of this reform from the perspective of business, consumers, and also from just a technical perspective, given some of the complexities that Chris has alluded to. We have, if I start in the centre, Sarah Court, Commissioner of the ACCC, recently appointed for an unprecedented third term and chair of the CDR committee. We have to her right, Emma Penzo, Policy Director of the Australian Banking Association, previously the Strategy Manager for ING Bank, and with more than a decade's worth now of board-level experience in the financial services industry. And next to Emma, we have Associate Professor Sven Feldmann from the Melbourne Business School and a key member in the Business School's Centre for Business Analytics, bringing expertise not just in corporate strategy, but also data ethics and how all of these things come together in the concept of corporate social responsibility. Moving to the other side of Sarah, we have Andrew Stevens, who's the Chairman of Innovation and Science Australia, advising the government on all matters innovation, science and research, but also Chair of the Data Standards Body, which is the body responsible for developing the technical standards that are actually going to bring the CDR into action. And last but not least, we have Justin Jones, who is a partner at Ashurst Australia, deeply experienced in competition law advice and litigation work, and at the moment very busy advising energy companies, energy being the second sector in which this right will be rolled out. So I think we're going to start with you being front and centre, Sarah. From your perspective, just what is the primary rationale for giving consumers greater access to and control over their data?
Thanks, Caron. Good evening, everyone. Well, I'm delighted that Mr. Harris is in the audience this evening because I'm living your dream at the moment, Peter, with the implementation of the consumer data right in banking. And look, I think there's been a number, the PC has done a couple of studies and the one Peter led to some extent started this all off, but there's been a number of studies, inquiries, reports, Murray, Harper, Coleman, Finkel in energy that really talked about that one way to both improve competition and to improve outcomes for consumers was to give consumers better access to their data. And from my perspective, the primary rationale for this very significant policy change is that currently the value, and we've just heard from Chris talking a lot about big data, and really talking about the consumer data right and open banking is moving much more now into my data, data at a micro level, my personal data. Even though it's my data and it's relatively small or micro-specific to me, at the moment, the way that firms are set up is that all of the value of that data, whether it's my energy company, whether it's my financial institution, whether it's my supermarket, whether it's my credit cards, all of that data at the moment is being used, monetised, and the value that's obtained from that data is coming not to me as a consumer, but to those various companies and institutions that hold the data, and they monetise it in a whole variety of ways. They sell it, they use it for targeted advertising, they get insights from the data, but myself as a consumer, I'm not able to readily access that value. And at the micro level, I mean, we all know this, but the banks, the supermarkets, the energy companies, they know what we spend, they know where I spend it, they know what my family pays for a weekly shop, they know where I buy my petrol, they know where I live, they know how much electricity my family uses, and they know how much I pay for that. And so it goes on. And there is value for me as a consumer in relation to all of those data points. And so what the consumer data right is about is effectively saying, let's move the value, or at least share the value of that data to a consumer rather than to the companies that at the moment are monetising it for their own advantage.
And Justin, what would that mean for the way in which markets that are driven now by data work?
I think there's two observations that I'll make. Firstly, that in addition to this idea about ownership of data and it being my data that I have some control over, is a notion that companies that have the data have developed a stickiness, if you like, with that consumer, and therefore the ability for someone to effectively move, to churn to competitors, is that effectiveness is increased or enhanced by the ability for that consumer to say, please take my data from that company and give it to this company, and now they know everything my previous company did, and there may be benefits in that. And for the businesses that I'm involved in advising, that's both a threat and opportunity in the sense that that will perhaps increase the portability of consumers, not just the data, but the portability of consumers, because they can better tailor the offers and the way that they deal with consumers who've moved over, rather than leaving the data stuck somewhere else. People have odd affinities to their data. For example, I think you get behaviour like, I have had the same account number since I was 8 because I joined the Dolomites at the Commonwealth Bank, and therefore when I move there's some feeling of loss that I now have to change my account number moving over to another person. You certainly had that in telecommunications, mobile phone numbers in the past. I think the other observation I just wanted to make briefly is that there's an assumption that businesses that have this data are able to monetise it and use it. And in my experience, that's not necessarily true. A lot of people have a great deal of data and they all believe they've got to do something with it. But if their core business is financial services or energy, they're often focused on just the old-fashioned provision of goods and services and don't really know how to look at this information they've got and turn it into some other revenue stream or some other product that enhances their profitability.
I'm interested to hear the use of the words ownership and property in that dialogue. Indeed, those were words that the Productivity Commission deliberately steered away from, rather taking the view that data should be a shared asset to the benefit of all, and the CDR would facilitate the opening up of data and the opportunity that it provides for an economy as a whole. And that leads me to my next question. So if we take competition as a given for the policy objectives underlying this reform, what other policy objectives are either complementary to, and in view of my last comment, perhaps we might think about innovation along those lines, or in tension with the primary rationale? Sven, have you got thoughts on that?
Well, I think one of the objectives that even the ACCC was laying out is to enhance the social license that these businesses enjoy. Currently, there seems to be a view that businesses take great advantage of having access to the data and that the consumer is not really benefiting as much from it. Now, of course, we are benefiting from it, so if advertising is targeted to us, then it is more relevant to our decisions and possibly more informative. Having access to that kind of data by various providers presumably would be beneficial to consumers in a more broad way. But coming back to the notion that what is being shared is an individual's data, so basically a data point. And I think Chris has made the point that an individual data point isn't worth very much. It's actually not the big data, but at least a sufficient amount of data and the insights that can be gleaned from the data that is really valuable to a business. So sharing an individual data point, I think, can only have two positive effects. One is either it helps the business gain greater insights into how to deliver their products, that would be a good thing, or it provides, or it lowers the transaction costs that the business has in setting up and providing us with an offer. So to the extent that we are targeting the latter, namely lowering transactions cost, that's, I think, a great thing. But in that case, it's not necessarily necessary to share all my data. The bank may have a lot of information that it uses to provide a particular service to me, but another bank only needs certain parameters in order to make a competitive offer and therefore vie for my business. So I think as a consumer, it's not clear whether we are not throwing too much of the baby out with the bathwater by giving access to potentially a very broad set of attributes that a business has accumulated over its customers.
Caron, can I enter in here? Because the way the legislation does not talk about ownership and property. It talks about access and control. And secondly, that there are three parties. There is a consumer, there's a data holder, and there is a data recipient. And how value is, and this is the competitive context, how value is derived from this regime relies on an improved offer being made to the customer, the consumer, either by the data holder because of competitive tension or by the data recipient. But in the end, the improvement in the offer, because of it being more a higher degree of fit with your particular requirements, if you look at the responsible lending context, one part of responsible lending is to understand the objective of the consumer and to justify that there is a degree of fit in relation to that offer. So it relies on the competitive tension, ideally between the holder and the recipient or the recipients, and an offer being made that is superior to the offer that is currently being made. So there is an important competitive dynamic here in this small data, and this is sensitive and personally identifiable data. And the difference between our regime, which is a consumer data right, and the UK's open banking regime, is that it is the first sector of an economy-wide right. So if you put electricity data and your usage and payment data together with your financial services and your banking data, then there's a possibility that the combination of that data at your particular point, I disagree that it's of little value, is that it would enable someone to put a more tailored financial and energy offer to you in relation to solar panels on your roof that fits exactly your energy requirements and your financial circumstances that neither a bank or an energy company could make in the past. And that is something that in the innovation and competition context is going to be something quite exciting to look at the empirics, as Chris has encouraged us, because that is at the heart of the regime. It's not ownership, it's I have the right as a consumer to direct that data held about me is made another. And if you look at other sources, you want to really understand consumer data. Those of you who have a reasonably long-term GP and you've had regular blood tests, if your company, the company that your doctor sends you to is one of the regulars and they have 10 or 15 years of your blood test data, that's consumer data. Your flight data on Qantas Frequent Flyer or Velocity with Virgin is customer data. And you think about the implications of all of this data, but with you at the centre. And so I think one of the big things we haven't talked about yet, Caron, is consent. Because the on and off switch here is about informed, complete and time-limited consent. And that part, and Lawrence here as well from CPRC, we've spent a lot of time in the data standards body and working with ACCC on the consent flows and understanding how Australians view. Because today, you have a notice-based consent that on page 37 of your terms and conditions of your banking contract, it tells you what uses will be made of your banking data. One of which is we will provide it to credit bureaus, whether you like it or not. One is we will allow companies that use screen scraping to access your account because you have given them your account access credentials, including your password, and we will meet that request. right? And already one of the banks has said they are already looking at the time they will phase out that notice-based consent and move to an explicit consent at a fine-grained granularity. So if you want to talk about how fundamental this is, I think consent really sums it up.
Sarah, you might want to comment on that, because it's an interesting position for a competition authority to be in, designing and stewarding a reform for competition purposes that has these other very live policy dimensions, sensitive policy dimensions like privacy and data protection, but also data security involved. How does a body like the ACCC wrap its head around those new policy domains and how to produce an integrated reform that gets the balance right?
Well, it involves a lot of talking, a lot of stakeholder liaison, and an awful lot of meetings and committees. So you're quite right, Caron. I mean, this is a new area for the ACCC, and I don't want to just talk about it in terms of it being all about competition. I do want to talk about it being very much consumer-driven, with consumers at the heart of it. And as Andrew has said, we've done a lot of work on consent, but I think one of the very important communications about the CDR is it is completely optional. No consumer is being forced to share their data if he or she doesn't want to. And then in terms of the kind of issues that we have been grappling with or working our way through over the last 12 to 18 months or so, there's been a range, I guess, of competing issues. So we've got the banks on one side, who I think, and Emma will no doubt speak about this in due course, who I think are becoming increasingly accepting of the consumer data right, and now starting to recognise that not only does it offer some threats, but it also offers them some opportunities. We've got the privacy groups. Lauren has had a very active role in a lot of the discussions about this, who I think it's fair to say don't necessarily begrudge the CDR, but are extremely worried about data sharing, potential data breaches, the idea of this kind of personal consumer information sort of whizzing around the economy between financial institutions and fintechs and energy companies and the like, I think is something that we can all intuitively think, look, we need to be very careful about that. I think we've got the general consumer groups who are, again, pretty optimistic about the CDR, but are also very concerned that it's not just restricted to, a particular socio-demographic. What about vulnerable consumers? How are we going to make sure that the opportunities the CDR offers are really extended beyond the sort of your mainstream consumers? And just a slight tangent. I mean, Andrew's right, it is all about competition, but there's a whole range of potential use cases for the consumer data right that go well beyond just, what's the best offer on my mortgage. There are potential opportunities for budgeting applications, for real analysis of spending, for financial counselling areas to be able to provide advice in a far more efficient way than is able to be done now. And I think we're only really starting to think about the sorts of use cases that are out there. So the ACCC has been in, and on the other hand, I've forgotten the fintechs who we haven't had a lot to do with at the ACCC, who are telling us, look, all of these issues and worries about IT and security and privacy, they're a load of rubbish. We're ready, we're here. Just give us the data. There's a screen scraping going on right now, ACCC, and if you make consent too hard, if you put in too many frictions, then we're not going to bother to even come and play here. So there's a whole range of competing tensions. There's a whole lot of IT builds that we're responsible for. We're working very closely with Andrew and his data standards people. We're working very closely with the Office of the Information Commissioner, who is a fellow regulator with us in this area. We're learning a whole lot about privacy and privacy standards, and we are implementing a privacy regime within the consumer data right ecosystem that goes well beyond the current privacy protections now. There's a whole range of talking, and that's just in banking. And as Andrew has said, we've got energy that is champing at the bit to follow very close after.
Well, you've spoken about the bank's attitude, so we should come to you, Emma. How is the CDR seen by banks, and what you might say may or may not be translatable to how it's seen by the incumbents in other sectors? A risk opportunity, just another big compliance burden? Give us your insight on that.
Well, good evening, everyone. Look, I think an entity's response, or an organisation's response to something like the CDR is really dependent upon how you perspectivise it. And if you perspectivise it from, it's my data and I want to keep it and I don't want to share it because people might take my customers from me, then of course you're going to end up in quite a defensive position. But that's certainly not the perspective that the banking sector is taking. I've reperspectivised it from a much bigger context actually than even what we've been talking about today. And know it or not, understand it or not, CDR is at the precipice of the new data economy. Now, when I've mentioned that in the past, people have said, what is the data economy? But CDR formalises the very beginnings of the exchange, the formal exchange of data through the economy. So I remember back in the 90s when I was a junior consultant at a firm, and we used to talk about the information superhighway and how it was going to change everything that we ever knew. Fast forward 18 years and it actually has changed significantly. Never back then did we imagine we'd carry the world's knowledge base potentially on our wrists. And I think we're on the very same precipice with the CDR. We might not understand it. It might be a clumsy launch come February. But it's actually going to change the way in which commerce happens. And I think once you understand it and accept it from that perspective, then as an entity, your strategists will be looking at it and saying, okay, what are the strategic opportunities and what are the risks and what do I need to cover for here but how can I actually go out and get ahead of the game? So I would be encouraging any fintechs or energy codes that perhaps are still sort of on the edges of CDR to take a much bigger perspective. We don't know where we're going to be in 10 to 20 years' time when it comes to data sharing and the way in which data is going to be used in this economy. And it's certainly the case that the first movers are going to develop that entrenched position and actually move the CDR forward in a way that that responds to the way in which customers are interacting with CDR. When it comes to our members, so I picked up this portfolio in April this year, so I'm fairly new to it, unlike Sarah and Andrew who've well and truly neck deep in CDR. I too am neck deep, to be quite frank. But our members, I've not experienced any reticence from the banks at all. I've just experienced full gung-ho, full throttle embracing of this, and they're working very, very hard to meet those timeframes. What their use cases are, I don't know, and they're keeping that quite close to their chests, as they should, but know that they will be competing, and I'm really quite hopeful that they're going to compete beyond just, cheaper market rates or cheaper mortgage rates, or if you get a mortgage from me, I'll stick a few solar panels on your roof. I'm quite hopeful that they're going to be crashing through some concrete and actually creating new market opportunities that comes with the data that they will be sharing and receiving.
So I'd be interested in your perspective on what you've heard Emma say, Sven. If you're in the corporate boardroom, what would you be counselling directors of the large players in our concentrated sectors of the economy to which this right will apply to be thinking about in respect of this new development?
I guess one thing that it certainly does is shift the access to markets from the big players, entrenched incumbents, to the new fintech companies and smaller players, and therefore to be cognizant of that and not to be resting on their comfortable cushions as they currently are. So that certainly is an invigoration of competitive aspects within any industry that will be touched by this. I think also from a consumer perspective, the prospect of having much more personalized offers or products or advice that you might be getting based on much richer information sets, I think is a big promise as well. And one danger in that case is also that products may become a little bit too complex, and they're so detailed and specialized that it is hard for the average consumer to then make a sense of it. And so maybe that then provides the opportunity for aggregators or consultants, maybe robot or algorithmic consultants, to advise users as to what the best offer is, and they in turn will be relying on that data to which they have access. So we can imagine that there is really a very different type of interaction between the current large players and their customers, maybe through several layers of intermediaries even, that help the consumer deal with the new complexity.
Andrew, I was going to come to you actually specifically.
Yeah, I
on
was
this
just going to
issue of
comment there because
consumers,
I've been 18 months on this journey, nearly 19 actually. And when we first were involved, the people we met from the big four were policy and regulatory. Today, the people we're dealing with are product, strategy, and technical. And I think it's a national evolution, and there's a lot of general counsels, in-house counsels today who are looking at this now saying, well, banking is live with product reference data from July, all 4 banks, and we're going to consumer data in February. So if this is going to gather momentum, we better understand it. And so they're starting the process at policy and regulatory. The reality is that if you stay in policy and regulatory, your mindset's going to be compliance, and you will lose. You will lose. Because you're basically going to say, I'm going to comply as a data holder, and I'm going to make data available so others can pick off my high-value customers. And Boston Consulting Group, when we met with them, because they monitor all the fintechs around the world, every single one, capital raising the works, they're making a particular study of open banking in the UK. And we said to them, where are the value pools that happen here? And that they think the use cases are, in general terms, one is serving underserved customer. And the existing data holders are the ones in the best position to serve the underserved customer, and in relation to capability to deal in this space, in the data economy, the existing players with the technical and digital resources are in better shape than anybody because they've got balance sheets, they've got experience, and they're their customers. And so they have an extra motivation, because the ones at risk will be those who are in the averaged world of large corporations who are paying higher than they otherwise should be, or are not getting the service commensurate with the high price they have. The other one is the aggregation play. And again, you look again in the central positioning of financial data and your banking transactions, deposit, loan, credit card, mortgage, etc. And you put other data and other consumer data up alongside that. So digital capability. And so I think, some of the banks, without naming the ones, have had 85 to 100 people working for 2 years on this. And some have spent, I understand, I don't know, but I understand they've spent $100 million preparing. Now, no one is spending $100 million to comply. They are, and we don't know. We don't know what the rollout will be, but there I think you'll see a very active response from the existing players, as we will see an active response from fintechs and startups, because in the data economy and in the digital economy, the gold is through the insights from data. And the ultimate is customers who you can encourage to share data with you because of trust relationship, that you will have a leg up. And so in really fostering the innovation and competitiveness of Australia, starting with financial services, then this is, I think, a very, very powerful lever, very powerful.
I know you want to get a question in, but can I just sort of also bring it back to the real tangible for the CDR and banking? Because there's a lot of talk about innovation and best offers and the kind of competition that will come, and the use cases will eventuate. But sort of sitting as a consumer now, it seems to me there's a whole lot of just very straightforward and simple practical things that the CDR and banking will do. And I'm thinking about really simple things like, I don't need a big new offer from a new fintech. I just want to move my business from one bank to another bank. But I've been set up with my first bank for years. I've got all my direct debit accounts, all my regular credit card payments, and I look at it and I'm just tired. I just cannot face physically picking up all of that information and handing it somewhere else. But the consumer data right should allow me to do that very easily. And that's where I think some of the early gains and early competition will come. Similarly, let's say that I've still got my my Dolomite CBA account that I'm in love with from when I was 8, but I have a range of other accounts as well. Let's say I have an investment loan or a mortgage with someone else, or a term deposit with another institution that's got a high interest rate. Well, the consumer data right in banking should enable a fintech or another provider to provide me with a dashboard that will enable me to see all of my financial circumstances across a whole range of providers in the one place. So I think these are very easy, tangible gains that we'll get at a very early stage. I agree use cases will develop, and when energy comes online, there'll be a whole new lot of those. But some of these are very straightforward and very immediate and very hard right now.
And Justin, you might like to reflect on that, either what you've heard about what might prove to be a boon for the Big Four, which may not be the ultimate policy outcome being sought, or on how this is being seen by the big energy companies.
It's interesting because when you look at this debate, there's everything you said, and Andrew, your description of a world where people can combine financial services data and energy data and come up with innovative offers that don't otherwise exist. It goes to this question of what data sets are we actually going to share, because at the moment it's sector by sector, and so we're focused very much on, okay, what do we need to do to move people around financial institutions, and then are we adding energy and saying, well, they're going to collect all of the data from both sectors and allow them to be combined and share them with an institution that you might not otherwise have ordinarily shared that data, or is the consumer expected to be able to divide it up? I think there's a lot of opportunity, but there's a lot of complexity in it that is important to recognise. And so when the people are spending $100 million on products, and at least you'll be surprised at the large amount of money that's also spent on just compliance in that number, thinking about how all of this plays out is difficult, particularly in an environment where we're still talking about what the data set is going to be. And so there's a bit of a sort of a chicken and the egg in that what are you going to share depends on what you think is useful or not. And what you think is useful or not may depend on what you're going to share and what different businesses value and what they're able to use. The only other point that I'd make is that there's an assumption sometimes that the data is going to be used to make better and perhaps more cost-effective options. But you'd be silly if you're in products to only think about how to reduce your margin. The other way to do it is think, well, where are the opportunities where you know this consumer doesn't care about how much they're paying, so I'm going to charge them more. The world isn't just about reducing prices from the business perspective.
Can I just address that point on the data? Because in the banking case, there's been a lot of thought as to what the data is and what it will be over time. And it's sort of the way I look at the CDR regime, and it develops like a T, that over time banking will get deeper on the vertical and then we'll go to other sectors on the horizontal. And so in the case of banking, there's been a lot of thought there, but the use case is very important because in a technical sense, the data that I need for a budgeting app and a budgeting service is quite different for the data I would need to make financial planning recommendations. And therefore, I would need historic data and much greater scope of data to do financial planning than I do to say and you see a proliferation already in banks, large and small, and financial services companies offering, I'm planning, I want to buy a new pair of sneakers, I'd like to get to Argentina on holiday, and all of these budgeting apps that are coming now thick and fast already, you can see the preparation to compete that's underway. The question then will come down in relation to energy. And what Houston Kemp know very well is that the structure of the electricity industry is quite different from the structure in banking, and that there is no one holder who has all of the data. So the person that has the billing data and your cash payment data is the retailer. There is a metering company that holds the metering data. There's the market operator who holds net settlement of energy units data. And no one has all of that data. And the question really is, because we are not developing unique standards and indeed unique rules for each sector, and somehow we're going to then try and weld them. There is one set of rules and there is one set of data standards that we are applying, And our expectation, and the reason why on the advisory committee we had electricity representatives on there, and telco reps for that matter, was for exactly this purpose. Because the way you have an economy-wide impact to encourage and nurture competition, but also innovation, is you have interoperability. And so one of the implications is, because Caron, the point isn't about whether the banks or the fintechs win, it's that the consumer wins. And we're doing a regime that the consumer is first, second and third in our minds, the consumer. And then the question is, how will the competitive dynamics deliver that? And then if I add other sectors in an interoperable way. So the definition of consumer in the current banking scenario is a customer who has an account and accesses that electronically. In electricity, only 20% of customers access their account electronically. Right, so there's fundamental differences, and it's why it's a very useful case study to do next. And we've asked for expressions of interest for people to be involved in the advisory committee that will be configuring specifically for energy. There'll be some cross-membership of that, but it'll be very interesting to see how it works. But there's a lot of thought that's gone all the way from the Treasury, ACCC and Data Standards Body in an iterative process, because we did these concurrently, to look at the nature of the data. So if you, for example, joint account. Joint account sounds simple, but the consent requirements and expectations of a joint account should both of the two people who hold the account consent? Should one consent and they're advised by the recipient of that consent that the other person has? Because the use cases we did and some of the consumer experience research we did were people who are in a difficult relationship and family environment are not really keen on the other person having total consent over their banking data. Other people who are financially vulnerable, who may be being lent on today by service providers, are we just got to make sure that, again, we have all of our use cases that say, no, that there is a fail-safe here. Because, as Sarah said, it's optional. No one is obliged to make any data transfer or any data available to anybody. But we're just trying to look at minors, people with dementia who hold a bank account, for example. How are they all covered? Well, the bottom-up view from the data is very, very helpful in this context, and electricity is another example.
So there's two recurring C words that I hear across the panel. The first is consumers and the other is complexity. And if you put those together, I want to come back to you, Sven, because you were the first one to talk about complexity. Just what challenges are we really facing when we think about consumers taking advantage of this new power, this new right they've been given? And Andrew, you might want to comment on this, Justin, Sarah, well, all of you possibly. I'm thinking about an article I read in the Fin Review this week, which gave statistics showing consumer inertia and status quo bias at work, in utilities, in banking, just the appallingly low rate of switching that has gone on despite these sectors having been opened up to competition many moons ago now, and the problems with consumer behaviour. Can we expect consumers in large numbers to flock to this new power? And if not, how do we push them over the edge?
Well, who knows, right? We don't know. But what we do know is that consumers are quite lethargic when it comes to these things. And there may be two reasons for that. One is just behavioral economics, that people have this status quo bias, or sort of this just menu cost of changing what you do with only minimal benefits for you in the short run might not lead you to actually do it. And so people keep their same accounts and same type of products for way too long before switching over. We probably can't really address that other than through nudging or some aspect like that. The other one is actual transactions costs. As I think Sarah was saying earlier, it is such a pain to change all of your banking relationships. And if it only were the case that we can, all my automatic payments, if I can switch to a different bank and a new bank account number, all the automatic payments will now be drawn out of that. So if we had true number portability as we have in the telecommunications sector, that probably would solve the problem. But I'm not sure to what extent the data sharing actually will allow that, because yes, maybe the new provider will now know who is the beneficiary of these direct transfers, but they can't on their own then realign them. So I don't have the technical knowledge of how this is going to work. But the other C, which is the consumer, I'm also really curious about, because it was said several times now that the consumer is in control. They can choose to share the data or not. I am not so sure if that is going to be the case, because any new offer can say, well, we will make you an offer, but in order to qualify, you need to share your data. Or maybe we don't allow that. Maybe we have to make it possible for consumers to opt out, in which case you might get the worst of all offers, because their inference is going to be, well, if you're not willing to share your data, it must be bad data. It must be telling us that you're a bad customer. And so it would lead to this unraveling, basically to this implicit compulsion that you actually have to share your data in order to get a differentiated or appropriate offer. And so I'm not so confident that the consumer actually still is going to be in control, but rather that we simply, like the consent buttons that we have now, that we simply need to click yes, okay, and all our data will be shared to the new provider.
Andrew, I know you're going to have something to say in response to that, and I want to hear from Justin too, but Emma, can I ask you, are the big four banks likely to be positively going out and informing customers about this new capacity on their part and encouraging them to use it, or is it something they'd prefer to let consumers find out about themselves?
So I guess that I do have, look, in terms of consumer education, there's significant work that needs to be done, and that's something that we are speaking with the regulators now, just now as we're beginning to turn that hump of the API development, about to start the testing. Our banks, our members will most certainly do their part in terms of educating customers, in terms of explaining how data is to be used, in terms of explaining what's going to happen to their data. Certainly I would expect that the dashboards that many of them are building, or all of them are building, would be information rich in terms of explaining to customers exactly who they've shared their data with, what data they've shared, in accordance with the rules as per the ACCC. So yes, absolutely, our members will be playing their part. But I think it's not just a matter of just explaining to customers this is what's going to happen to your data. Just as we hear about significant levels of deficiencies in financial literacy levels, I think we run the risk of having similar deficiency in data, in consumer data knowledge as well. And I think the way in which we design and embed some of these rules is going to either perpetuate that or ameliorate that. So joint accounts, for example, is an example. So we can either allow one party to simply hand over their right to data sharing to another party and allow that other party to have complete control of their data and what happens in the economy, whilst the other party is quite happily oblivious to how it all works, doesn't understand how their data is being shared, and we effectively start to create an underclass of undereducated consumers. So if we are serious that this is the first step of the formal data economy, where data can actually be shared through the economy, then there needs to be very serious action taken in terms of explaining to customers and the consumer and the general Australian population what this means. Certainly our banks will play their part as far as it goes towards the banking sector, but there's as Andrew has alluded to, there's a much bigger sort of economy-wide play.
Andrew, Data 61 has done quite a bit of user testing amongst consumers already, and there's a pilot going on amongst bank consumers as we speak. Can you give us, just in a nutshell, what are some of the key insights from those early tests?
So we have tested in 2 rounds, and there's a 3rd round about to kick off to do a number of design things. And we asked 200 consumers over-indexed to vulnerable customers in all locations in Australia, all capital cities, rural, remote, everywhere. And we asked, without any conditioning, would you share your banking data? And 55% of Australians said yes. 55, without any qualification whatsoever. So obviously 45% said no, we wouldn't. Then we explained the CDR regime and the testing, and 39 of the 45 who said no said yes. Right, so we're down to up to 94% quickly. But what's interesting is that if you get to it, we talked a little about the third C, which is consent, but the other one is revocation of that consent. And we found that that revocation and the ability to revoke your consent to stop everything happening, and that to then lead to either de-identification or deletion of the data that has been transferred, increased willingness to share, and things like reputation and privacy issues decreased it. And when we asked in relation to the three parties here, your data holder bank, the app provider who is like the data recipient, and indeed the government, overwhelmingly customers trusted the banks as number one in terms of looking after their data. And so some of the reasons why there's been 100 people up to over an 18-month period is banks have never architected their systems to enable outsiders to access that data within a 2-second response time. And so some of the major technical heavy lifting that's gone on, because the standard says that the data transfer has to be made in the same time frame or less than the primary channel that the customer accesses, and that relates to 2 seconds or less because it's your internet banking response time. And so banks have not architected, they didn't even want their own staff getting near it. They wanted absolute secrecy and security to keep that data locked away, which is one of the reasons why, as Chris said, is many organisations don't make full use of the data they have because it's so heavily protected. But customers trust banks on their data security. And so information security is the other thing we haven't talked about much, but we've looked at consent flows, and one of the things you'll see that we've recommended in the customer experience guidelines that will find their way into the standards is that there should be statements made at any time. You should never provide your password to another party. You should never. Because screen scraping says, give me your password and I'll access your account so I can look at your account. And that is how most of the big credit type organisations are working today. So the UK have announced the sunset of screen scraping. It's a material improvement in security of data and indeed in due course downstream privacy of that data. But the consumers are very interesting that they bring their own misinterpretations when they don't know. So the point, and Lauren, if she was up here, she would be talking about how she is working over both the ACCC and Treasury to say, tell me about the budget for customer education. Lauren, true? Absolutely, because it's not enough yet. It's not enough yet. It's unpopular for me to say that, but it's not enough yet.
Never will be, I suspect. Justin, you may want to reflect on anything you've just heard, but I would also like you to come to the thorny issue of derived data or value-added data, because this was one of the big contentious elements of the various consultations that led up to this legislation. And perhaps you might just give us the benefit of your views on whether or not derived data, and you might explain that more for the audience, should be included in the definition of consumer right data.
Sure. Quick reflections on two of the C's. Consumer, what a world we live in. You will have a group of consumers who are highly engaged and they will voraciously read the privacy policy and the new disclosure and the materials that the regulator comes out with and try to understand it and be across it. I think there'll be a large number of people, maybe a majority, I think things change over time, who really will just expect the government to look after it. And I think that if you look at some of the other changes in law, unfair practices, unfair contract terms, that's reflected in that. There's this idea that, well, there just needs to be some standard, somebody look after it, and I don't have to learn everything about it. On complexity, and I think this links into derived data as well, is that when you're just thinking about data, you can start with the simple things. If I just take energy, I've got my consumption, I know how much I've consumed, and then you add some other complexity like when did I consume it, what time of day, what part of the year, and then you start to layer on other other aspects to it when you're deciding what data set to share. And meanwhile, businesses are looking at the data and they're using it to develop basically new data. Data's derived from the existing data, which they may find useful for other reasons. And the great battle, at least from a business perspective, is that they feel very strongly that their investment in analysing the data and then applying work to it to produce new data, that they very much would like that to be kept in-house. That's not really just the data associated with the consumer that somebody observes, but in fact is the product of intellectual work and resources to create new data that other businesses will very much want to see. Consumers may still, because we talk about data and increasingly in terms of rights and property, even though we're talking about access in interoperability, I think over time consumers the view changes such that they think, well, if you've used my data, if you've exploited it to make something valuable, I'm entitled to part of that value. So that derived data should go along with my core data set. And I think that tackling that problem is very difficult because, as Sarah mentioned before, you'll have fintechs and other companies saying, well, look, if you're going to take that away from us, make us share that, the product of our analysis and intellectual rigour, then why would we bother doing anything with it in the first place?
And I might get you to reflect on this issue too, Sarah, because from my understanding, the legislation really left this as a bit of an open question as to whether or not derived data would be in-scope data, and handballed it to the ACCC to work out in liaison with stakeholders from one sector to another. So just how do you approach that issue? Because it exposes a tension, doesn't it, for one of the rationales in this regime to be spurring innovation, but at the same time one doesn't want to take away the incentives to continue data-driven innovation of the kind that Justin talked about.
Yeah, no, I think that's right. There's been a lot of conversations with the banks about derived data and the intellectual property that is associated with the data. So there's the concept of raw data, which might just be, for example, your transactions and how much you spend and with what trader. And then most of us will be familiar with in our credit card statements or our account statements, there are then trader descriptions, and you can have raw descriptions, which might just be a meaningless number or a company name that is not associated with Joe's Deli where you get your coffee from every morning. And then some banks apply their own IP over the top that says, look, this particular number is Joe's Deli where you get your coffee, so you can then properly interpret your credit card or account statements. And then the sophistication of that derivation or the use of the derived data sort of ever increases. And so, you know, the view that we've taken at the ACCC is, at least in the early instances, we're looking predominantly at raw data. We recognise that the data holders, the banks, have got various IP in a range of these applications. And there's a couple of other things, Caron, that we haven't touched on. I mean, the first is that we have, as Andrew has alluded to, we've been working on really in a parallel way the legislation and what is included in the legislation, which is now was passed a few months ago. The ACCC has been working on rules, and Andrew's data standards body has been working on the standards. So we've been working on those things in parallel, and given the timeframes that we have had, we've recognised that the rules in particular are going to have to be an iterative process. So we have tried to keep things for the first version of the rules, we call it the lockdown version, that was published at the end of August. Those rules will be built on and added to, and we'll have a second phase of the consumer data right in banking coming online in July, which will deal with the tricky issue of joint accounts and consent that Andrew has talked about, and will also extend to mortgages, which are not included in the first tranche. Can I also, just because I know we'll run out of time soon, but I think it's important, I just want to make sure that people don't have the sense that the consumer data right is effectively introducing an unregulated free-for-all of data flying around the economy in a way that it doesn't already, that we're introducing some sort of anarchic chaos which is going to allow consumers to be ripped off and exploited. what the CDR is really designed to do is to actually put some real protections and infrastructure around the sharing of data. So one of the things we haven't talked about is the accreditation process. And it's not the case that anyone rocks in and can say to me, look, Sarah, can you give me all your data, please? You go to the ANZ and tell them to give me all your personal data. Anyone who wants to be the recipient of consumer data, so personal consumer data, needs to be accredited by the ACCC, and the rules build in some very stringent accreditation guidelines about your IT security, about regular audits, about your directors and managers being fit and proper people, whether you've been found to have contravened any laws that are relevant to the ACCC's assessment. And the ACCC and the committee that I chair through the Commission are going to be responsible for making decisions about which of those particular providers should be accredited. And I can tell you, at least as things stand at the moment, that is not going to be a straightforward process. And once a body is accredited, then there will be regular IT audits and security audits and reporting at the moment through to the ACCC. The other set of additional protections that are built in is there are enormous range of privacy protections built into the consumer data right regime that go beyond the privacy protections that exist out in the general economy. And there are very significant penalties that will apply to anyone that is found to be engaging in misuses of data, representing that they're accredited when they're not. And the penalties are the same as the current penalties under the Australian consumer law. So those penalties are, I won't go into what they all are, but they are up to 10% of a company's revenue. So it's not, in my view, the situation, and we have all of the same investigation powers that we have under the current Australian consumer law regime. So I think I just want to make sure people are comfortable with the fact that while we don't want to dismiss the security issues and the potential privacy issues, data is flying around the economy at the moment. We read about data breaches every day. The ecosystem of the consumer data right should add a whole lot of protections for consumers who want to share their data, not by handing over their banking passwords, as is currently the case for millions of Australians, to my surprise, that do that, but within a safe confines of a protected ecosystem.
And speaking of accreditation as one of the key protections that you've referred to, that does raise the issue of reciprocity, which was another thorny aspect of the consultation in the design of this scheme. And I might get you to comment on this, Emma, just explain to our audience just what that issue involves and whether or not it's been resolved to the satisfaction of the ABA's members.
Sure. So the concept of reciprocity has evolved, actually. My understanding is that when the concept was first floated, it referred to, well, if an entity is going to become an accredited data recipient in order to receive banking data under open banking, then they should reciprocate like. Now that like meant that, I'll just take a hypothetical example. If an energy company became an accredited data recipient for whatever reason, that their data should be made available to the banks, which is their transactional data for their particular products. Now, through discussions and debate and what have you, that concept of reciprocity then evolved into like for like data. So if an accredited data recipient comes in and requests sort of banking data, if they have banking data themselves, then they trigger their entry into the regime as a data holder and are therefore obligated to provide their banking data in a like way within the regime. Now, so to that extent, okay, well that's fair enough. The banking sector has pretty much accepted that that's the status quo. I suppose if we sort of refer back to Andrew's comments about the opportunity for innovation and what have you, innovation within an ecosystem, innovation theory holds that you need to be able to provide disparate forms of data to be able to wash them together, potentially, this is my interpretation, in order to be able to create the new magic and the new product proposition. So where you don't have data reciprocity of the type that was originally requested, you don't get the new types of data sets then coming into the ecosystem, which can then be washed and married against different data sets. So that's basically reciprocity at a very simplistic level, and the banking sector has accepted where we've landed, and we're just moving on with it.
Sorry, I don't want to correct Emma in a direct way, but I just want to talk about language of reciprocity, because I think when I start hearing discussions about if you get my data, then this person can come in and take my data, I feel very uncomfortable, because what we're really... A data recipient cannot come in and ask for data, right? A consumer will go to a service provider and say, can you please, I'm going to direct that this bank share my data with you in order that you can provide me with services. So it's a consumer-driven obligation on a bank. The principle of reciprocity is not saying that automatically, if this fintech asks this bank to share data, that fintech automatically has to share data in return. That's not what reciprocity is about, as the rules are currently drafted. All that it means is that data recipient, the fintech company, if they hold data, if they hold consumer data, they then transfer under the regime, and I apologise for the complexity of all these terms, but they effectively are deemed to be a data holder for the purposes of the regime as well. So they receive data. If they hold consumer data, they are then designated to be a data holder. If a consumer then directs them to share data, that's what they do. But it's not this sort of automatic reciprocity that if I give you this consumer's data... Exactly. That's not it.
I apologise. I took a shortcut then. I apologise.
Well, it is very hard to distill this complexity into something where we're so constrained in time. And given the time, I'm going to do a final observations a la Insiders on the Sunday morning ABC and ask each of our panellists very briefly to tell us, 5 years on, you're looking back, what do you expect to see if you're to conclude that this experiment has been a success?
Sure. So 5 years on, I was going to make a joke about it being repealed, but I don't mean that.
Only a lawyer would make that joke.
No, 5 years on, I think the clearly understood data rights that are portable, which there's evidence that consumers utilise them, and there's evidence that it has resulted in improvement in the consumer experience and hasn't stifled innovation. Now, how you measure any of those things remains to be seen. But I think
might have some thoughts on that.
the proof will be, I think, partly anecdotal and then partly empirical.
Andrew.
I would hope that the CDR has been designated economy-wide, and there's no exceptions. And so we have it right, and that's, in other words, to do business in Australia, that's how we do it. Secondly, that consent has become very fine-grained in terms of purpose, duration and revocation, and it becomes a norm here, and it's quite different here to anywhere else in the world, and we have a vastly different consumer experience because of it. Thirdly, because there's consumer data in frequent evaluating use, and that has transferred its way into the way that businesses operate on the global stage, and our global competitiveness is up a significant margin. That would be success.
Ambitious. Sarah.
Yeah, I love Andrew's ambition. I'm going to bring it right back to the implementation challenge. So I think if in 5 years' time we look back and there has been no significant data breaches or issues, that the CDR is well known and understood by consumers and that they are actively using it, that it is just business as usual in Australia. If I want to share my data, I do that. I do that with confidence, and as a result of that, we have the big four, perhaps not with the current 70-80% of residential mortgages and the like, but people are using their data to generate competition and innovation. Then I think we will have achieved success, and that energy will also be online. But knowing what is involved in implementation and development of the rules in 5 years' time. I'm not sure we'll quite be economy-wide yet by then, Andrew, but let's be ambitious.
Emma.
Thank you. So that's 2024. Probably our banks would have had this CDR open banking operationalised for about 3 years. So my criteria, success criteria, would be it's trusted by the Australian banking population. It's used. It's actively used. That's the place that they go to, and that it facilitates commercial trade. So that would be my hope for 2024. I share Andrew's vision, maybe for 2029 perhaps, and in that vision, the major assumptions that I'm making are that we've had no major security breaches of major customer data breaches. So if we get one of those, then we might not achieve this vision. Also that ideally that we are stepping towards a conversation around all data being included as part of the CDR. So that's going back to what Andrew said as well.
Last but not least.
So first of all, I want to say it is such a courageous experiment that we're running here, because it hasn't been done anywhere else, and we are putting a lot of chips onto that particular table. So I'm going to make one prediction that I'm pretty confident that it will bear out, and the other one is a little bit more speculative. One is that there will be winners and there will be losers. And right, and we hope that the consumers will be a large part of the winners as well. And the more speculative part is that a few years ago, we thought that the internet is going to really democratize the marketplace. And almost the opposite has happened. There has been a large concentration with the very large players. With some very large players, globally even. And the speculative part here is that that might be the result of this as well. We don't know exactly how it's going to pan out, but especially the winners, or those who see the opportunities and monetize and transactionalize them very effectively, potentially have a lot to gain and might gain a lot of concentration, which is not exactly the intent of this new regime.
Wow, so we're ending on a low note. But there is so much to think and talk about there. Please, can you thank such a wonderful panel for distilling us the complexity.